A federal appeals court is now hearing the case of three students who were sent home from a California high school. It was on Cinco de Mayo. They refused to remove T-shirts they were wearing that depicted the American flag. The school officials argued that they were concerned that their patriotic T-shirts would spark racial tension on a holiday that was meant to celebrate Mexican heritage. But those students claim their constitutional rights were violated, and the incident sparked passionate arguments on both sides when all of it started back in 2010.
It's always been Hispanics versus Caucasians. It's been like that in our history. We cannot sugarcoat this. We cannot hide it.
Students were not making a political statement. Their goal was simply to show their pride in their country. As parents, we are proud we have raised young men who stand up for what they believe in.
Well, joining me now is the lead attorney on the case representing those students, William Becker, Jr., who's also a First Amendment attorney. Bill, great to see you. Thanks for joining us.
Good morning, Jamie. Thank you.
So the Ninth Circuit, interesting court of all the courts, to take a look at this case, and it was in court now. The briefs had been filed. The arguments have been made. What do you think will happen?
Well, you know, with the Ninth Circuit, it's anybody's guess. This case has taken about 3 years to wend its way simply to oral argument, which my colleague Rob Muse from the American Freedom Law Center argued this week before the Ninth Circuit. It appears that the Ninth Circuit may look at this case and decide that the trial judge was wrong in granting summary judgment and send the case back for trial.
Let's tell folks what the judge decided. The lower court said the school had a right to make the kids turn their shirts inside out because, as the school argued to the Ninth Circuit, they had sufficient evidence that there would have been a disruption, that they had to protect the students. Is that their argument? Do I have it right?
That's their argument, and Jamie, it's not a strong argument because under the Supreme Court case precedent, the Tinker case, there has to be an actual threat of disruption, and there wasn't any actual threat of disruption on this occasion. My clients were sitting in the quad minding their own business. They'd been in class for 3 hours. There'd been no evidence of any disruption that would occur. Any evidence of disruption in years past should have tipped the school administrators off that the way to cure the problem, if they anticipated any disruption in the school environment, would be to foreclose any celebration of Cinco de Mayo if they felt that that might lead to racial tension.
And they did not do that.
No, they didn't.
Let me ask you this as well. The kids had worn these shirts to school on other occasions. It was just on this holiday that the school tried to enforce a policy because of a perceived threat. What are your damages? What is it that you're seeking? These students have since graduated and moved on.
Yeah, these cases are not taken for the purpose of recovering money damages. If anything, the students would be awarded $1, nominal damages. What they're seeking to do is to vindicate not just their constitutional right of free speech, but to set an example and precedent for all Americans. These were American students at an American high school celebrating their American patriotism. They weren't trying to do it in a provocative manner. And to suggest that the American flag is a provocative symbol that needs to be suppressed on an American school grounds is absolutely going down a bad path. And I really think that if this case sets that kind of precedent, we're actually looking at something much like the delegitimization of traditional marriage.
All right. Well, constitutional lawyer William Becker, Jr., as this case is considered by the Ninth Circuit, please come back and talk to us when they rule. Thank you very much.
Thank you, Jamie.